In the first module, I'm going to provide an overview of the Canadian criminal justice system. Keep in mind that basically we're going to summarize the entire course, so I'm going to go through this fairly quickly, but don't despair if you feel. So in this module, we're going to do basically 5 things. Provide an overview of the basic tenets and principles of the Canadian criminal justice system. Outline the division of powers between the different level governments in Canada vis-a-vis the criminal justice system, so who's responsible for what. Talk a bit about the 5 main institutions within the criminal justice system, a brief summary of the process within the criminal justice system, so from arrest all the way to parole, and then finish with a discussion of some of the challenges, weaknesses, and limitations that confront the Canadian criminal justice system. The criminal justice system in Canada, or any country for that matter, is basically a system that has been implemented by the government to maintain order in society. It's essentially a system of social control. It's a system that is about creating laws and regulations and enforcing those laws and regulations to basically ensure that people behave. So it's the most important institution as far as maintaining order in any society. So that's the most fundamental purpose of the criminal justice system. In Canada and in any other country, there's basically 6 tenets to the criminal justice system, and we'll talk about this in greater detail in subsequent modules. The first is justice, the second is deterrence, the third is punishment, the fourth is protection, the fifth is rehabilitation, and the sixth is reintegration. So justice is basically about ensuring that defendants, the accused, are given justice, and that society in general is given the justice it deserves through the prosecution of criminal offenses and the enactment of criminal codes. The second is deterrence. The criminal justice system is in part there to try to deter individuals from breaking laws or behaving badly. And there's 2 kinds of deterrence. The first is what's called general deterrence, and that's the enactment of laws and other systems to ensure that the general public doesn't break those laws. And the second is more specific forms of deterrence, and that is putting measures into place to ensure that an accused, a defendant, does not commit a crime, or in particular does not commit a subsequent crime. So putting someone in jail is supposed to be a way to deter them from committing crimes in the future. So deterrence has both a general and a specific function in the criminal justice system. The third and most obvious function or tenet of the criminal justice system is to punish. It's to punish people. Again, the whole system is based on the idea that if you do the crime, you do the time. And punishment is strongly related to deterrence, because the idea is if you have strong or punitive punishment in place, that's going to deter people from committing crimes. The fourth tenet is protection. Again, the criminal justice system is in place to protect individuals and protect society from criminals, from offenses. The fifth tenet is rehabilitation, and this is about basically rehabilitating or treating offenders so that they don't commit more crimes in the future. And finally, there's the aspect of reintegration, and this is often not considered a tenet of the criminal justice system, but it's a fundamental one in Canada. And basically this means getting offenders back into the community, out of incarceration, or even avoiding incarceration altogether. And so that the idea is once they're in the community, back in society, civil society, the chances of treating them and rehabilitating them increase greatly. And research basically bears this out. Most offenders rehabilitate or are treated or offend less after they have been reintegrated back into society. So in Canada, it can be argued that historically, or at least since the Second World War, the two most important principles of our criminal justice system is justice and reintegration. Justice because following the enactment of the Charter of Rights and Freedoms in 1983, there's an incredible amount of emphasis on ensuring the rights of defendants are protected. And certainly there's a lot of criticism there. A number of people believe that the system bends over backwards to protect the defendant at the expense of the collective security of society. But there's no doubt that justice is an absolutely fundamental aspect of the Canadian criminal justice system. And the second most important principle is reintegration. The whole system in Canada is really about getting the offender back into the community. And that's why probation is the sentence that's handed out the most in criminal courts. Probation is basically about the offender avoiding any kind of incarceration and serving their sentence within the community. And secondly, even if someone is incarcerated, the emphasis is on getting them out of the correctional institution, back into society, back in the community as quickly as possible. So justice and reintegration are absolutely critical aspects in the Canadian criminal justice system. But now that we have a conservative government in place under Stephen Harper, much more emphasis has been placed on punishment. And as we'll talk about throughout the course, the Bill C-10 and other policy decisions they're making has really focused on increasing the punitive nature of Canada's criminal justice system. In other words, making sure there's more and harsher punishment for offenders. And many believe that this is going to undermine the justice tenet of the criminal justice system because offenders are going to be denied justice and their rights under this more punitive system. So in summary, while there are a number of tenets of the criminal justice system in Canada, historically we've emphasized justice and reintegration. But as we've discussed, the criminal justice system is a dynamic, ever-changing institution. And with the current government, we may actually be seeing a far more greater emphasis on punishment in the future. One of the first things we need to understand about the Canadian criminal justice system in Canada is that administration of the system is divided between different governments, in particular the federal and provincial governments, but also the municipal government as well. This division of power is a reflection of the federalist system in Canada. And what a federal system basically means is that you have different levels of government with different powers and different jurisdictions. And this is no different with the criminal justice system. So each level of government in Canada, the federal, provincial, and municipal government, plays a role in the criminal justice system. The division of responsibilities between the federal and provincial governments was actually spelled out in the Constitution Act of 1867, so the legislation that basically created Canada. The basic division is that the federal government is responsible for writing and enacting criminal laws, basically deciding which behaviors constitute criminal offenses and how they should be punished, while the provincial and territorial governments are responsible for administering the justice system. And that includes policing, law enforcement, the prosecution of most criminal cases, and operating correctional institutions. Now, while the provincial government has been given constitutional authority to administer the criminal justice system in Canada, the federal government also operates a national police force, which is the RCMP. It does prosecute some federal offenses, including narcotic offenses, customs and excise offenses, national security offenses. It also appoints some judges and manages some courts. It operates a federal correctional institutions for offenders who receive sentences of more than 2 years in length, and it also operates a parole board for federal inmates, mostly in provinces outside of Ontario and Quebec, because those two provinces have their own parole boards. So basically you see that the system is divided primarily between the federal and provincial governments. So the federal government is primarily responsible for creating laws, although it does enforce some laws through the RCMP federal laws, while the provincial governments, through the Attorney General of each provincial government, is responsible for administering those laws. So the vast majority of policing is actually under the jurisdiction of provincial governments. Even when the RCMP is involved in municipal or provincial policing, that's basically still under the jurisdiction of the provincial governments. And municipal governments, you have to remember, are basically a child of the provincial government. So provincial governments have complete responsibility over municipal governments. So even when municipal governments have their own police force, such as most major cities, the provincial government is still ultimately responsible for that police force and can create laws and legislation and policies that ultimately affect those police forces and how municipal governments police their communities. So if you look at this slide, basically you see the division between the three levels of government. With the federal government, the primary departments is the Department of Justice and the Department of Public Safety. With the provincial government, the vast majority of the criminal justice system is administered through the Ministry of Attorney General, and so each province has its own Attorney General, which is one of the most powerful positions in the province. And then you have the municipal government, which primarily is responsible for the municipal police force. So the only real role of municipal governments is managing and funding the municipal police force. So within the federal government, under the Department of Justice, they're responsible for writing federal statutes. They're also responsible for a vast array of criminal justice policies. They, as I mentioned, undertake prosecutions, mostly in drugs, but also national security. The federal government is responsible for the Supreme Court, and they also appoint some judges. In addition to the Department of Justice, the federal government also operates the Department of Public Safety. And this is another powerful institution because it operates so many powerful criminal justice agencies. So under the Department of Justice, under the Department of Public Safety, you have the RCMP, you have the Correctional Service Canada, so the public safety is responsible for all the federal correctional institutions in Canada. The National Parole Board falls under the Department of Public Safety. The Canada Border Service Agency falls under the Department of Public Safety, and also the Canadian Security Intelligence Service. So you can see how powerful public safety ministry is based on the number of agencies and the powerful agencies it has. But with that said, the Department of Public Safety is still second to the Department of Justice as far as power in the federal sphere of criminal justice is concerned. Within the provincial responsibilities, if you look at the box just below the federal government responsibilities, their tasks or their power include the administrative justice. So again, while the federal government writes the criminal code, it's up to the provinces to administer the criminal code, and that's done under the auspices of the Attorney General. Provincial governments are also responsible for provincial correctional institutions. They're responsible for provincial and municipal police. And Ontario and Quebec also operate their own probation and parole systems. Within most other provinces, the federal government operates the parole system for those provinces. And finally, under municipal governments, as I mentioned, their prime contribution to the Canadian criminal justice system is to operate a municipal police force. They will also enact municipal bylaws, but again, these are not criminal laws. They're not criminal code laws, so technically it's not within the criminal justice system. Municipal governments will also operate jails, or what's often called lockups, and those are temporary prisons for offenders that have been arrested and need to be held in jail before a court, or between a court date and when they're transferred to a correctional institution if they're convicted. And we should finally make mention that the community has a critical role to play in crime control. It doesn't play a huge role in the criminal justice system because that, as I've mentioned, is exclusively run by governments. But you do have important roles to play, such as volunteers in the criminal justice system. Citizens also are jurors, so we play a major role in the criminal justice system as jurors. And outside the criminal justice system, the communities and citizens are critical to what's called crime prevention. And this is initiatives to work with police or even work autonomously in preventing crimes, whether it's through neighborhood watch programs or citizen patrols or programs for at-risk youth. So while the community plays a critical role in crime prevention in society, it's still a fairly minor role, notwithstanding the importance of juries. And the criminal justice system is still primarily under the auspices of the federal and provincial governments. There are five main branches that make up the Canadian criminal justice system, or any criminal justice system for that matter. There is the legislative branch, which is involved for creating criminal justice policy and more specifically criminal law. There's the police, there's the criminal courts, there's corrections, and then there's parole. And while we refer to the Canadian criminal justice system or Canadian criminal justice institutions or branches, what you have to really keep in mind is the system's made up of people. And because it's made up of people, whether it's police or crown prosecutors, judges, jurors, correctional officials, parole officers, probation officers, they're all subject to mistakes and flaws. And so the system is very much a human system that lives or dies by the ability of people to make decisions under, in some cases, very stressful and dangerous circumstances. Because the system is so much based on human decision making, the system takes into consideration the discretion of the individual actors. In other words, the Canadian criminal justice system, the actors in the Canadian criminal justice system, the police and the judges and the prosecutors, have a tremendous amount of discretion as far as their decision making is concerned. And that's absolutely essential to a very rigid criminal justice system. It's essential to interjecting some discretion and some flexibility in the system. So a police officer, for example, has a tremendous amount of discretion as to whether to lay a criminal charge or not, or how to proceed with a particular case. If they find some kid with a bag of pot, for example, they have discretion on how to proceed. They can lay a criminal charge, they can simply confiscate the pot, they can refer the young offender, the young person to treatment, or maybe in some cases just to write an essay on why marijuana is bad. So the police don't automatically have to lay a criminal charge if they see someone breaking the law. So they have a tremendous amount of discretion. The courts have a tremendous amount of discretion. The trial judge is given a tremendous amount of discretion as to whether or not or how a case will proceed. A crown prosecutor has a tremendous amount of discretion on whether or not a criminal charge laid by a police officer will go to trial. So a crown prosecutor can actually say to a police officer, well, you've laid this charge, but we're not going to proceed with it because we don't think you have enough evidence. Correctional officials have a tremendous amount of discretion as to how to deal with offenders in prison, on when and if they should be released in the community. The parole board has discretion, obviously, on whether or not convicted and sentenced and offender in the custodial system can be released on parole. So discretion is a fundamental aspect of the criminal justice system. It's exercised by all actors in the system, the police, the crown, the judges, the correctional officials, and it is a very important aspect of the system. And that's why these mandatory minimum sentences being introduced by the Conservative government is so controversial, because what it does is it takes away the discretion, especially of the sentencing judge. A sentencing judge has a tremendous amount of discretion to determine the kind of sentences to be imposed on the convicted defendant. And they're allowed to do so because every case is unique and every defendant is unique, and some defendants have very mitigating circumstances that should lessen their sentence, and some have aggravating circumstances which should lengthen their sentence. But it's really up to the judge to take into consideration all these different circumstances. The criminal law may lay out a sentence, but it's really up to the judge to determine the appropriateness of a sentence to each individual case. And so when the government introduces mandatory minimum sentences, that takes away the sentencing judge's discretion. And many argue that by taking away the discretion of the sentencing judge, you are really undermining justice in the system, because the defendant is not receiving the justice based on his or her circumstance. But the important thing to remember here again is the importance of discretion within the system, and how each of the actors, the police, the prosecutors, the judges, correctional and parole officials, all have a tremendous amount of discretion to make decisions and work within the parameters of this very rigid criminal justice system. The first branch of the criminal justice system we're going to talk about is that which is responsible for policy making and criminal law in particular. And as we talked about in previous slides, it's the federal government that is responsible for writing and enacting criminal laws in Canada. In particular, technically it's Parliament that's responsible for putting forth criminal laws, but it's really the federal government, the executive, the Prime Minister, the Department of Justice that is ultimately responsible for writing laws, and then it goes through Parliament as a bill, and once that bill becomes a law, it's enacted by the Parliament of Canada. So we have a number of criminal statutes that has been produced by the Parliament over the last century or so. The most important is the Criminal Code of Canada. This is by far the most critical piece of legislation with respect to the criminal justice system in Canada. But we also have other pieces of legislation that are important to the criminal justice system. The first is the Controlled Drugs and Substances Act, which regulates all substances, illegal substances in Canada. There's a separate piece of legislation exclusively for young offenders, for youth involved in the criminal justice system. And this is separate from the criminal code in that there's a number of different laws and processes and punishments that are applicable to youth that are not applicable to adults. There's also the Anti-Terrorism Act, which polices national security issues. So it's both terrorism is both a criminal issue and a national security issue. It's important to make a distinction right now between summary and indictable offenses, as well as we'll talk about this distinction in subsequent slides. Basically, criminal laws or criminal code infractions are divided into two categories. Summary offenses, which tend to be more minor offenses, things like break and enter into a house or stealing from a car. And these are generally offenses that are punishable up to 2 years. And then you have the more serious crimes, which are called indictable offenses. And these are, as I said, more serious crimes, including assault and murder and sexual assault. And these generally are crimes where the sentence is 2 or more years. And so it's important to make this distinction because not only is punishment different for these two categories of crimes, but the processes in the criminal justice system sometimes differ depending on whether you've been charged with a summary or indictable offense. Now, in addition to criminal laws, the federal and provincial governments also enact a number of other policies that affect the criminal justice system. And because the provincial governments are responsible for the administration of justice, while they cannot enact criminal laws, they certainly do enact numerous policies which have important ramifications for the criminal justice system. So policies that affect policing, policies that affect correctional systems, policies that affect the functioning of courts. So while the provinces don't have jurisdiction over writing criminal laws, they do have significant powers because they are responsible for policies with respect to administering the criminal justice system. Finally, it's really important to note that the criminal laws in Canada and the entire legal system is actually founded on what's called the common law system. And the common law system originated in the United Kingdom and it was imported into Canada in the 17th and 18th centuries. And basically what the common law system means is that decisions made by judges in courts is based on the idea of precedent. And that basically means that when a judge makes a decision in the criminal court, other courts follow this precedent. And in a hierarchical system, the hierarchical court system, the higher the court is in the system, the more the lower courts have to follow that decision. It's basically mandatory. So if the Supreme Court makes a decision on a particular legal aspect of the criminal justice system, then all courts have to follow that decision. So this common law foundation for the Canadian criminal justice system is really important because The court system in particular is very much grounded in this idea that courts, judges in courts, follow the decisions of other courts. And so whenever a judge makes a decision in a particular case, they'll often refer to other decisions, especially important decisions made by judges and justices, and they definitely have to follow decisions made by the Supreme Court. The second branch of the criminal justice system we're going to talk about is the police. Obviously essential to the criminal justice system. They are the front lines of the criminal justice system. Their responsibility is to enforce criminal laws. But again, keeping in mind that in fact the majority of police's time is not enforcing criminal laws, but enforcing a vast array of other types of laws, including traffic laws and municipal bylaws and highway traffic laws, for example. In Canada, we basically have three levels of police, just like we have three levels of government. We have federal police, provincial police, and municipal police. So the municipal police make up the vast majority of all police in Canada. There's about 67% of all police officers are serving municipal police forces. And we should make a distinction here that not only do we have urban police forces like the Vancouver Police or Toronto Police or Halifax Regional Police, but even when the RCMP is undertaking municipal policing, they're still referred to as municipal police. So while we talk about municipal policing, this can include actual urban police forces like the Toronto Police or the Vancouver Police Force, but it can also include RCMP, which is responsible for a lot of municipal policing outside of Ontario and Quebec. The second level of policing is provincial police, and there's actually only 3 provinces in the country that have their own provincial police forces: Ontario, Quebec, and Newfoundland. All other provinces are policed provincially by the RCMP. And so provincial police have a number of different functions. The 2 primary functions is to police jurisdictions that fall outside of the major urban centers. So for example, highway patrol. Provincial police in all provinces are responsible for patrolling highways and enforcing traffic bylaws on highways. And the second role of provincial police is to police municipalities which cannot or have chosen not to enact their own police force. So in Ontario and Quebec, many of the smaller towns in those provinces are actually policed by the Ontario Provincial Police or the Sûreté du Québec Quebec Provincial Police Force, and the same in Newfoundland as well. While in most provinces outside of Ontario and Quebec, it's the RCMP that conducts provincial policing. And so they will do the municipal policing in most of the smaller towns. So what you see in Canada generally is that the large cities in this country, like Vancouver, Toronto, Edmonton, Calgary, Winnipeg, Regina, Saskatoon, Toronto, Montreal, Halifax, they have their own police forces which report to the municipal governments. In many of the smaller towns, and even mid-level sized towns, suburbs, for example, the RCMP do municipal policing there. And as I mentioned, they also do provincial policing. So basically what happens is that the RCMP contracts themselves out to these provinces and municipalities. So they basically work on contracts. So the province of BC, for example, has a contract with the RCMP to provide provincial policing. And the province of BC, through the Attorney General, also has a contract with the RCMP to provide municipal policing in a number of suburbs outside of Vancouver and in other parts of British Columbia. So while the city of Vancouver is policed by the Vancouver City Police Department, Richmond and Surrey and Langley and Delta are policed by the RCMP, but they're basically doing it on contract to the provincial government. If the provincial government wants to get rid of the RCMP and bring in its own provincial police force or own municipal police forces in those jurisdictions, they have every right to do so. And this is actually a fairly controversial issue right now because there's a number of municipalities in British Columbia, for example, that aren't that happy with RCMP policing, and they've threatened to begin their own municipal and provincial police force. We haven't seen that yet, but it certainly has happened in the past where some municipalities have threatened to bring in their own police forces. Now, the third level of policing in Canada is federal policing, and basically the RCMP is the federal police force. We like to refer to the RCMP as a national police force, but technically they're a federal police force. So like Ontario has the OPP, the federal government in Canada has the RCMP. And again, so the RCMP technically has been empowered to enforce federal statutes. So the drug statutes, national security statutes, customs statutes, so anything to do with smuggling, anything to do with immigration is federal responsibility, federal policing responsibility. So technically the RCMP enforces, as a federal police force, they enforce federal statutes, but as a contract police force, they will go out and enforce the criminal code and other municipal and provincial bylaws as well. So again, technically the RCMP is a federal police force that enforces federal laws, but they also contract themselves out to provinces to act as municipal and provincial police forces. So they in that capacity are enforcing criminal laws and municipal and provincial bylaws. So again, just like we have a federal system in Canada that includes municipal, provincial, and federal governments, our police is broken down into municipal, provincial, and federal policing. Although again, the RCMP transcends their role as a federal police force and also provides municipal and provincial policing on contract to certain provinces in this country. The third branch of the Canadian criminal justice system we're going to talk about are the courts, the criminal courts. The broader context of this is that the courts operate in a number of capacities within Canada. So obviously courts are not just involved in criminal cases, they're also involved in civil cases. So civil cases are where you have two private litigants suing each other, for example, or a mom and dad fighting over custody of a child, a couple companies suing each other. There's a number of different other kind of courts. There's military courts and tax courts. So within the Canadian legal system and the court system, we have a number of different courts. Obviously, what we're going to focus on in this course are criminal courts. And so we basically have 5 levels of courts in this country. The lower courts, superior courts, appeals courts, and then the Supreme Court of Canada. Keep in mind that the provincial government runs much of the court system in this country, and as such, given the diversity of the way different provinces run their affairs, there is some differences in how the court system is structured within each province. But generally, what you see on the slide reflects what most provinces have in place with respect to the criminal court system. So at the very bottom of the scale are what we call the lower courts, in other words, the provincial courts. And the provincial courts deal with the vast majority of criminal cases. The vast majority of criminal cases are summary offenses, so less serious offenses, and so the provincial courts will deal with a vast majority of criminal cases, given that most are summary cases. The next level is what we call the superior courts, and generally superior courts are broken into 2 different divisions. You have the trial division, and the trial division operates much like the lower courts do in that they hear criminal cases, but in this case they're hearing more serious criminal cases, so these are indictable cases. And then you have the appeals division, and the appeals division of a superior court hears appeals either from the lower courts or from the trial division. So at the superior court level, you have both a trial division that will hear serious indictable criminal offenses, and then you have the appeals division where cases will be appealed either from the lower court or from the trial division of the superior court. In many provinces, they also have another appeals court, and this appeals court will hear appeals from the trial division or even the lower level appeals division. Again, each province is a little different here. Some provinces just have one appeals court. Other provinces may have two appeals court. But in general, appeals court is there to listen to appeals that are made either by the defendant or by the prosecutor with respect to the outcome of a criminal trial. And the final court in the land is the Supreme Court. And again, the Supreme Court doesn't simply rule over criminal law or criminal court cases. It rules over any legal aspect of Canadian society, essentially. But the Supreme Court of Canada is the final appeals court in this country. And we'll talk about this in a little greater depth when we talk about the courts. But basically, the Supreme Court rules on the technicalities of laws. So if a defendant has been prosecuted and convicted of murder, the Supreme Court is not going to rehear that case unless there's a technical, legal, constitutional aspect of the case that the Crown or the prosecution is appealing. For example, a Crown or the defense counsel may argue that the defendant's rights have not been respected by police. And so they will take that to the Supreme Court of Canada, or at least make an attempt to take it to the Supreme Court of Canada. And then the Supreme Court of Canada will rule on whether the rights of the defendant were in fact abused or protected by police. So much of the cases that the Supreme Court hears in Canada, the criminal cases, have to do with rights and technical legal issues. And in particular, it has a lot to do with the appeals with respect to the rights of the defendant. Why? Because the Supreme Court is the final arbitrator of the Canadian Charter of Rights and Freedoms. And it's the Canadian Charter of Rights and Freedoms that is the most powerful piece of legislation in this country. Why? Because, especially with respect to the criminal justice system, it basically serves as a way to limit the powers of the government and to ensure that justice is served. And as we talked about earlier in this module, justice is a critical aspect of the Canadian criminal justice system. So it's ultimately the Supreme Court of Canada that has the power to determine whether or not the Charter of Rights is being administered with respect to criminal court cases. And so many of the cases that are brought to the Supreme Court have to do with whether or not the police and the courts have followed the principles of the criminal justice system. And those principles are codified in the Charter of Rights. And we talked before about common law. As we mentioned, the Supreme Court is the most powerful judicial branch within the court system, and any decision made by the Supreme Court of Canada has to be followed by all other lower courts, including provincial courts, superior courts, and appeals courts. The fourth branch of the criminal justice system we're going to talk about is corrections. And again, correction system is broken down by federal, provincial, and municipal governments. At the federal level, as we discussed, under Public Safety Canada is the Correctional Services Canada. This is the agency that's responsible for operating all the federal correctional systems in this country. And basically, defendants who have received 2 or more years sentence are housed in a federal correctional system. Provincial governments also operate correctional systems, again, that report to the Attorney General of each province. And defendants that have received less than 2 years are incarcerated within the provincial correctional system. And you also have community supervision as well. So when we talk about the correctional system, we tend to automatically associate that with prisons. But keep in mind that the vast majority of offenders, people who have been prosecuted and convicted of sentences, of criminal offenses, actually don't go to jail. They are released on probation. So in other words, they go into the community. And again, in addition to probation, there's a number of different other sentences that a sentencing judge can hand out where a convicted offender does not go to prison but goes back into the community. So there's things like statutory release, and of course, an offender can be convicted of community service or house arrest. So someone who's convicted of a criminal offense enters the correctional system, but that does not mean they automatically go to prison. Okay, the correctional system can also include probation and group homes and home monitoring systems. And of course, there's parole as well. Once someone's paroled, they're still within the correctional system. They're simply serving the rest of their sentence out in the community and not in prison. Now, we don't include municipal lockups as corrections because technically a municipal lockup is simply a holding cell. It's not really considered a part of the correctional system. So while it's a jail, it's only meant to be a temporary system to hold someone generally between, say, after they've been arrested and when they haven't received bail. If they've received bail, then they go in the community. If not, they're transferred to usually a provincial or correctional institution. So the most important correct branches of the correctional system is the federal and provincial. But again, keeping in mind that just because you're in the correction system doesn't necessarily mean you're going to jail, because the vast majority of people who are sentenced in this country based on a criminal offense actually serve their sentence within the community through probation or other community-based sanctions. The final branch of the criminal justice system we're going to talk about is the parole branch. And basically the parole branch is there to ensure that offenders are reintegrated back into society and that they're supervised while in society. So we need to make the distinction between parole and probation. So probation is an actual sentence that's handed down by a judge. So if someone is convicted of a crime and then given probation by a sentencing judge, that individual serves their entire sentence within the community. Parole is basically what an offender gets after they've been released from prison. And in Canada, the majority of parole decisions are made by what's called the National Parole Board. And the National Parole Board is an agency within Public Safety Canada, and it's made up of a number of appointees, political appointees, who are responsible for determining whether or not an offender within the prison system can be released on parole. Now, there's various types of paroles as well. There's temporary release, there's day release, there's what's called statutory release. One of the most important things to remember about parole is that most offenders that go to jail are eligible for parole after they serve a third of their sentence. So once they've served a third of their sentence, they can apply for parole. They may not get it, but they certainly can apply for it. And after 2/3 of that sentence, that's what's called statutory release. And almost all offenders that are sent to prison are released after 2/3 of their sentence. Now, there's some exceptions, such as what we call lifers. These are offenders that have been convicted of first-degree murder. They have to serve their entire 25 years minimum. But most others, including violent offenders, are released after 2/3 of their sentence. So if an offender is sentenced to 10 years in jail, so that would be a federal institution, they actually are released after about 6 and 2/3 years, so a little close to 7 years. So very rarely does someone convicted of prison actually serve their full sentence. It's usually only convicted murderers, first-degree murderers that serve their full sentence. And again, the important thing to remember is that the parole system is absolutely integral to the concept of reintegration in society. So a principal tenet of the Canadian criminal justice system is to get offenders back in the community, or ex-offenders back in the community, where they have a much greater chance of rehabilitation and treatment. And parole is a fundamental aspect of getting offenders back into out of prisons, which are not nice places and not great places for rehabilitation, back into the community. And again, what's important to remember is that while they're on parole, they're still under the jurisdiction of the correctional system, and they are still to be supervised by the correctional system. In this case, if it's federal, they'll be supervised by federal correctional officials, and if it's provincial, by provincial correctional officials. With slide number 11, we're going to shift gears a bit. In the last few slides, we've talked about the branches of the Canadian criminal justice system. For the next few slides, we're going to talk about the process that takes place within the criminal justice system. And in slide 11, you see a very rudimentary, simple breakdown of the process. And the process basically begins where an offense is reported to police, or police discover a criminal offense in process. That individual's arrested or at least brought before the courts. A trial ensues, and the individual may be convicted or may be exonerated, released in the community. Following a trial, there's a sentencing hearing. And it's important to keep in mind that a criminal sentence is not handed down by the trial judge, but it's handed down by a sentencing judge. And again, there's numerous types of sentences that can be handed down by a sentence judge. As we mentioned before, once the sentence has been handed down, that individual either goes into the federal correctional system or the provincial correctional system. And again, just because they're in the correctional system doesn't necessarily mean they go to jail. They can be released in the community, and again, most are released in the community. And then you have various processes after someone's been sentenced: rehabilitation, parole, community supervision. So basically, the process is multi-staged, and the trial, the sentencing, custodial care, rehabilitation are all essential aspects of this process, which we'll talk about in subsequent slides. So as I mentioned, the first step, or the first stage in the criminal justice process, begins with police, and in particular the police interaction with the defendant or the so-called offender. And we'll go into this in more detail when we talk about police, but essentially there are various ways that a defendant can be brought before the court, or the ways that a defender can enter the criminal justice system. The one we hear about the most is an arrest. And again, the police officer can arrest an offender either with a warrant. A warrant is something that has been issued by the court, or based on probable cause. And what probable cause means is that if, for example, they find someone breaking into a building, then that police officer has probable cause to discern that this individual is breaking the law, and therefore can arrest that individual. The police can also issue an appearance notice to a defendant. And what that means is that instead of arresting someone and taking them to the police station and fingerprinting, they simply issue them what's called an appearance notice, and that requires the individual to appear before a court. So while we see on TV the vast majority of offenders are arrested and taken to police station for booking and fingerprinting, most individuals that are charged with a criminal offense simply get this appearance notice and are required to appear before the courts on their own recognizance. Now again, this is usually with respect to less serious crimes and with respect to individuals who don't deem to be a flight risk, and that's the vast majority of people who are arrested. It's really only a very small minority that are arrested and dragged into police station and fingerprinted and held in the police prison before they go to court. A summons can be issued by a justice of the peace for someone where police have laid a charge, and then the summons basically requires the individual to appear before a court. So a summons can actually be delivered by somebody working for the court, like a sheriff, and police are never really involved. It's basically police can go after the individual, but if a summons is served on an individual, it simply tells them that they have to appear before the court for a particular hearing or arraignment. And it's important to note as well that an offender or someone who's arrested or if issued a summons doesn't necessarily have to be held in jail. It's really at the discretion of police and later a judge to determine whether or not the person is going to be held in a temporary lockup or even a provincial police facility before their case is heard. The vast majority of individuals, again, are not put in a police lockup prior to their court case. They're simply released on their own recognizance and are required to appear before a judge for their arraignment or for their trial. And again, this reflects the fact that the vast majority of criminal charges are less serious summary charges. The next stage in the criminal justice process is the criminal trial process, and this is in fact broken into a number of sub-phases, you can call them, or sub-stages. Before the criminal trial, the very first step is for the charges to be read to the defendants, and this is what's called the arraignment. And it's actually very short, takes a couple minutes depending on how many charges there are, and it's simply a formal process where the charges are formally read to the defendant, and assurances are made that the defendant understands the nature and scope of these charges. The next step in indictable offenses is what's called a preliminary inquiry. And a preliminary inquiry is basically an optional stage, but it's there to determine whether or not there's enough evidence to proceed with this case. So when a police officer lays a criminal charge, he or she does so on the pretense that he or she is going to gather enough evidence to actually prosecute this case. In most cases there is enough evidence, in some cases there isn't, but it's up to a judge to determine whether or not there is sufficient evidence to go ahead with the case. And this is sort of a funnel process to get rid of any cases where a criminal trial is not warranted because there's not enough evidence. But again, a preliminary inquiry is optional, and it's usually at the discretion of the judge whether there is a need to determine whether there's enough evidence, and a preliminary inquiry is only held for serious indictable offenses. Following a preliminary inquiry is a bail hearing, and obviously this is only in cases where a defendant has the option of applying for bail, and these are for more serious offenses, and if the bail is not granted to the defendant, then that defendant will actually go to jail and be held in jail or a remand center before their trial. So the bail hearing, we'll go into this in more detail when we talk about the criminal trial stage. The bail hearing are actually fairly rare because they're only for more serious offenses, and the hearing is basically to determine whether or not the defendant can be released back in the community while waiting for their trial. The next stage is the trial itself, the criminal trial. The vast majority of criminal trials are by judge only. As we see on TV, there's often juries, but jury trials are fairly rare, and they're generally only for indictable serious offenses. The defendant can actually choose whether he or she wants a trial by judge alone or a trial by jury. And again, we're going to discuss the jury trial in much more detail later in this course. But it's important to keep in mind that the number one criteria within a criminal trial is that the defendant must be proven guilty beyond a reasonable doubt. So there can be absolutely no doubt in the mind of the judge or the jury that the defendant is innocent. And this is an absolutely fundamental part of the criminal justice system. And for a criminal conviction, this burden of proof is much different than the burden of proof for a police officer when they arrest someone. So when a police officer arrests someone, or a court issues a summons for someone to appear on a criminal charge, they're only operating on the burden of what's called probable cause, and this is a much less burden of proof than beyond a reasonable doubt. So probable cause basically means that, well, we think you've committed an offense. We have evidence to suggest you've committed an offense, and that gives us the right to arrest you. But you can't convict someone on that flimsy foundation. They has to be in the Canadian criminal justice system beyond a reasonable doubt. And following the criminal trial is the sentencing trial. So obviously this only occurs if the defendant has been convicted of the charges. And a sentencing trial, as the name suggests, is a trial where a sentence is passed down by a judge. So in Canada and in most other common law countries, the trial judge does not impose the sentence on the defendant. So the trial judge or the criminal trial process is only there to determine what a guilt or innocence, and if guilt is proven, then a separate trial is held, and that's where a sentencing judge actually hands down the sentence based on the circumstances of the case. As mentioned, the sentencing trial is separate and distinct from the criminal trial. If a defendant is found guilty, the next step is to be sentenced by a judge. And so the sentencing judge is different from the trial judge. And the sentencing judge has a number of different options as far as sentencing a criminal defendant, the convicted. The vast majority of sentences are for probation. In other words, the accused, the convicted, is released back in the community and serves his or her time within the community. So again, they're still within the correctional system. They're simply serving their time in the community. Obviously, the judge can also sentence a convicted defendant to prison. They can give him or her a suspended sentence, which means that they actually don't have to serve any other sentence. They can be fined, they can be house arrest. So there's various sentences that a sentencing judge can mete out to a convicted defendant. And we'll talk about these in more depth later in the course. What's important to remember is that a sentencing judge has a tremendous amount of discretion. He or she can take into consideration a number of different variables in determining a sentence. There's things such as a pre-sentencing report, which can be developed by the Crown Prosecutor, and that the Crown Prosecutor can ask for a certain sentence and argue why that sentence is justified. The judge can hear victim impact statements and take into consideration the wishes of a victim. And the judge takes into a vast array of other mitigating and aggravating factors. So a mitigating factor would be one that would lessen the sentence. So for example, if the defendant, for example, was accused of assaulting somebody, but say the person he assaulted was drunk, and he was drunk, and that can actually be a mitigating sentence, although it's controversial. Aggravating sentence is, or an aggravating factor is a circumstance where the judge can actually compound the sentence or make the sentence longer. So, for example, if the accused has a history of sexual assault and has been convicted of another sexual assault offense, then the sentencing judge can take that in consideration and make the sentence longer. And there's even statutes in the criminal code that a judge can take into consideration or has to take into consideration. So, for example, the criminal code, there's this provision in the criminal code that if a certain offense was committed by an individual as part of an organized crime group, then the sentence for that individual can actually be longer because it was committed for organized crime. Now, while a sentencing judge has a tremendous amount of discretion, there are certain sentences that have a mandatory minimum sentence. In other words, a judge has no leeway as to the sentence that he or she can impose. So the most obvious example is first-degree murder. A first-degree murder comes with an automatic prison sentence of 25 years, and a judge cannot deviate from that. They can't make it longer or they can't make it shorter. And it's also important to note, as we're talking about throughout this course, that the federal government, the conservative government under Stephen Harper, has brought in legislation to increase the number of offenses with mandatory minimum sentence. So, for example, the new legislation, Bill C-10, has a provision that if you're caught growing 6 or more marijuana plants, you're automatically sentenced to 6 months in prison. And so the judge has no discretion whatsoever as to the minimum sentence. The judge can't hand out a sentence of probation or community service or suspend the sentence. And this is where a lot of the controversy surrounding this legislation has manifested itself, is that judges no longer have the discretion, or at least the amount of discretion they had before. And many argue that this is undermining justice because it does not allow a sentencing judge to take into consideration the unique circumstances of each defendant. The next step in the criminal justice process is sanctions and corrections. Sanctions basically refers to how the convicted defendant is going to serve their sentence. And again, it's up to the sentencing judge to determine the sentence, obviously, whether it's going to be served in jail or in the community, or whether the sentence is suspended at all. So, as we talked about, the vast majority of convicted defendants don't go to jail. They're released on probation, or they're under community supervision. Some can be given suspended sentences if they meet certain requirements, such as entering a treatment program, or paying back, a victim if they broke into their house, which is restitution. So while someone who's been sentenced has to serve certain sanctions under the correctional system, as we've emphasized, that doesn't necessarily mean they're going to jail. It's up to a sentencing judge to determine whether someone's going to go to jail. And again, as we talked about, if it's 2 years or less, then if a prison sentence is handed out by a sentencing judge, 2 years or less means that they serve it in a provincial correctional institution, and 2 or more years means that they will serve it in a federal correctional institution. Parole is the final step that a defendant will encounter in the Canadian criminal justice system. And as we've talked about, parole is whether a defendant gets parole is a decision that's made by a board, whether it's a national parole board or the provincial parole board in BC, Ontario, and Quebec. Parole is really only granted to those who are incarcerated. So obviously someone that's received probation wouldn't get parole because they're already in the community. So what parole basically means is when and under what circumstances a convicted defendant can leave a incarcerated state, so can leave a provincial or correctional institution. And there's a number of different types of parole. So there's temporary absence, where a defendant has to, say, go to a hospital, or maybe there's a birth of his child, or they have to leave the prison for counseling. And usually this is very short. It's a few hours or perhaps a day at the most, but generally it's only for a few hours. And this is a decision that's made by a correctional official, whether federal or provincial, depending on what institution the convict is serving in. Another very common type of parole is what's called day parole. And these are, again, literally someone is released for a day. And it's basically a way to have the defendant prepare for full parole. And so they'll go out for a day, usually under supervision, sometimes not under supervision. And it's, again, the attempt is to try to prepare them for their full parole. And basically someone can be eligible for day parole when about 6 months before their full parole is granted. Now, full parole, as we've talked about, can be applied for by the defendant, by the offender, after they served 1/3 of their sentence. So again, doesn't mean they'll actually get the full parole, but they can apply for it. Now, full parole basically means that they're released from prison, they're still within the correctional system, but they're now on parole, and they'll serve the rest of their time in the community under supervision. Statutory release basically means that the defendant is released after 2/3 of their sentence has been served. So, and this is almost universal for all imprisoned defendants, in that the vast majority will be released automatically after 2/3 of their sentence. Now, that can be denied by parole board, especially if there's evidence that the individual has not been rehabilitated or treated properly, or that they're a high risk to reoffend. But again, the vast majority are released after 2/3 of their sentence. But again, the exception to this rule are people who serve a life sentence and they have no chance of parole for 25 years. Now, what's important to remember about parole, it's very controversial, without a doubt. There's some people argue that, these people have been convicted in prison, so they should not receive any kind of, abbreviated sentence. But parole is a fundamental aspect, again, of reintegrating offenders back into society. And what's important to remember is that when they're paroled, they're still under supervision of the correctional system. And contrast that to if someone is released after they serve their full sentence in jail. Once they're released after serving a full sentence, they're no longer under the supervision of the correctional system. And so there is no supervision of them, period. So they're out in the community. There's been no transition through parole or day parole or full parole, and there's no supervision. At least when an offender is on parole, they're under supervision, and that shows or that is shown to be important in reintegrating offenders and reducing their recidivism rate. In other words, reducing the rate at which they reoffend when they're released in the community. So just because someone is on parole doesn't mean they leave the correctional system. They're still, in fact, under the jurisdiction of the correctional system. They're simply serving their sentence in the rest of their sentence in the community, and they're still under supervision, not by a prison guard, for example, but by a probation or a parole officer. So thus far in this lecture, we've provided an overview of the main criminal justice branches and the process involved in the criminal justice system. We're going to end up talking about some of the challenges, limitations, and weaknesses of the criminal justice system. There certainly is no shortage of challenges that face the criminal justice system. It obviously has a very onerous and significant task in society, and has to overcome a number of limitations and problems within the system itself that makes its task very complex and very challenging. Certainly one of the most significant challenges that faces the criminal justice system is balancing the rights of the accused with the collective security of society as a whole. And this is the tightrope that the criminal justice system has to walk every time, is you have to respect the rights of the defendant, and you have to ensure that justice is served, but at the same time you have to fulfill the other fundamental tenets of the criminal justice system, and that is protecting society and punishing defendants and deterring others from committing crimes. So this is a very this is one of the most complicated and fundamental tightropes that the Canadian criminal justice has to walk. Another increasingly significant challenge is the fact that crime is becoming increasingly complex and multi-jurisdictional, and that means that police investigations are becoming increasingly complex and costly, and trials are becoming very complex and costly, especially trials that may involve organized criminals or financial crimes. Become very complex and sometimes very difficult for lay people like judges and juries to understand. Policing and enforcing justice in a multicultural society is often very complex as well. Within Canada, we've had very important cases that revolve around customs and traditions of different ethnic groups. In Ontario, there's been discussion of bringing in a type of Sharia law that applies to Muslims, and there's various cultural traits of certain ethnic groups that are not always compatible with, say, Canadian values, and they may actually be deemed criminal. So it's very difficult to enforce justice and to ensure justice is served while protecting society within this multicultural framework. And again, just by way of an example, the whole idea of someone having to swear on a Bible in a court of law, a Christian Bible, if you're Muslim or Jewish or Buddhist for that matter, should you be obligated to swear on the Christian Bible within a court? So this is just one example of many of the challenges that the criminal justice system has to face within a very multicultural Canadian society. At a more tangible level, the criminal justice system is very vulnerable to budget cuts. And so while you see the complexity of crime in some cases increase, police and prosecutions have had their budgets cut and made it very difficult to prosecute cases. The Federal Prosecution Service has very complex drug cases that it has to prosecute, yet it's seen its budget increase only minimally over the last few years. And so what this has done is contribute to the backlog of cases. And defendants have the right to have a speedy trial, but when the prosecution has such minimal resources, it's often very difficult to ensure that defendants get that speedy trial. So in some cases, defendants are actually released and don't have to go through with a criminal trial because their case hasn't been brought forth in a timely manner. We live in a society where many of the accused are tried in public before they're even tried in a criminal court. The people love crime, they love crime stories, and we have a media that is very sensationalized. There's an old adage in the media, if it bleeds, it leads. That means if there's a crime, especially a bloody crime, that often receives a lot of media coverage, which can bias a case against the defendant. And it also creates expectations in society, and it also creates fears. The fact is that crime has actually dropped in Canada quite a bit in the last few years, yet you wouldn't know that by the media because we're constantly inundated with stories about crime and especially violent crime, and that creates a perception that crime is actually increasing when it's in fact decreasing. Another interesting challenge is the police and the entire criminal justice system's relationship with the public. The police need the public. They need public to report crimes. They need public to cooperate with the police. But at the same time, they have to keep certain information away from the public, and the public can only get involved to such an extent. So on the one hand, police and the criminal justice system requires the involvement of the public, but at the same time, the system works very much to shut the public out of the system because it's a government-run system. So finding that balance between public input and then ensuring the privacy and the rights of the defendant is, again, a very difficult challenge for the criminal justice system. And this extends to the whole issue of victims. To what extent do we involve victims in the system? The criminal justice system in Canada and in most countries has traditionally been very poor at addressing the rights and the needs of the victim. And in some cases, the victims are completely ignored. In some cases, they're put on the stand in a criminal trial and then challenged by the defendant. Their integrity is challenged. Their honesty is challenged. And this is particularly troublesome when it comes to, say, sexual assault cases where the victim is put on the stand and some say, victimized again by the questions of the defense counsel. So these are just some of the many challenges that the criminal justice system faces in trying to ensure a just but fair and a fair system that ensures a collective security for society. In the previous slide, we've talked about some of the challenges that the criminal justice system faces. And there's been, out-and-out critiques and criticisms of the Canadian criminal justice system. Again, it's a system that's run by people. It's very much hostage to limited resources because it's run by the government. There's limited resources available. And there's the inherent challenge of simply trying to detect a crime and criminals and prosecute them. And certainly one of the most predominant criticisms of the criminal justice system is simply unable to cope with the actual quantity of crime in society. As our primary system to deal with crime, you have to keep in mind that the vast majority of crime is not detected, let alone prosecuted by the criminal justice system. Most criminal offenders are not caught. Most are not brought to justice. The criminal justice system has been criticized for failing to rehabilitate those offenders who have been identified in the criminal justice system. And again, the correctional system is probably the worst place to try to rehabilitate anybody. The criminal justice system also fails to address the underlying factors associated with crime and criminality. And it was really never created to do so. But when you think of it, here we have our primary institution to deal with crime, yet it's completely impotent to actually deal with the causes of crime. And so the system really only addresses the symptoms of much deeper social problems. And so when we're dealing with crime, the vast majority of our resources go into the criminal justice system, which does not deal with the cause of the problem, and a lot less money goes into aspects of our society that actually deal with the problem, the root cause of the problem. And so many advocate that we need to start shifting resources away from the reactive criminal justice system, which only addresses the symptoms of deeper social problems, towards more fundamental social institutions that can actually deal with the root causes of crime and criminality, like putting money into at-risk families and poor communities and into schools and drug treatment programs and things that actually can and have been shown to address the root cause of the problem. The criminal justice system may actually promote crime. The correction systems is a great place to go if you're an offender and want to meet with and network with other offenders. It's basically the university of criminal offending. It's a place to go not only to network with others, but to learn how to be a more effective and more ruthless criminal. Correction systems, very punitive systems, can have a detrimental effect on offenders. It can harden them, it can make them more chronic, and as I said, it's certainly not a place that's optimal for rehabilitating offenders. And again, that's why so much emphasis is placed on getting offenders back in the community as quickly as possible, because it's universally recognized that these are the best environments for them to quote unquote rehabilitate and reintegrate back into society. As far as critiques are concerned, we have ample evidence that the criminal justice system discriminates against visible minorities. Aboriginal people, African Canadians are disproportionately represented within the criminal justice system. And research has also shown that Aboriginal offenders and African Canadian offenders will get much harsher sentences than, say, white young offenders or white offenders who've committed the exact same crime. So the criminal justice system in Canada and throughout the world really is a system that does discriminate against visible minorities. And getting back to the issue of resources, again, the system is biased in the sense that if you have money, if you're rich, then justice works much more in your favor. Why? Because you can hire a good lawyer, you have the resources to pay for bail, but with respect to the poor, they don't have the kind of resources to get a good lawyer. And believe me, getting a good lawyer is fundamental to justice, or receiving justice, or receiving a acquittal in a criminal trial process. So not only is the system biased against visible minority, it tends to also be biased against the poor and biased in favor of those who have money. So just to finish up, flowing from the challenges and critiques of the criminal justice system, while the Canadian criminal justice system responds to law-breaking with investigation and prosecution and where appropriate, punishment, it does not, however, respond to every breach of the law. Only a small fraction of all the criminal acts committed in this country come to the attention of police, and even a smaller fraction of those are heard in the courts or lead to a sentence of incarceration. So dramatic is this attrition of cases in the Canadian criminal justice system that's often graphically referred to as a funnel. So if you look at this graph on the slide 20, using this hypothetical number of 200. So for example, if you've had 200 cases reported to police, only 100 of those actually turn out to be a criminal, where a criminal charge is warranted. Of those 100 cases where the police lay a criminal charge, 34 of those are cleared. In other words, the defendant never goes to court, is never criminally convicted. The charge is basically withdrawn. Of those that are charged, only 15 are actually convicted in court, which means that, again, the vast majority are acquitted. And then finally, of those 15, only 4 actually serve any kind of custody, ever go to jail. So out of the 200 cases that may be reported to police by the public, or in which the police identify themselves, only 4 of those actually ever go to jail. And again, this is a reflection of the criminal justice system, where the vast majority of crimes are undetected, and the vast majority of criminal offenders never go to jail. So why do we have this attrition of cases? Well, there's a number of reasons. As we've talked about, the vast majority of criminal offenses are never detected. Just think of how many drug deals go down at any given day in Canada, and how many of those are actually detected by police. It's a very, very tiny proportion. Despite the fact that most Canadians indicate a strong confidence in the Canadian criminal justice system, most victims don't report offenses to police. There's a high rate of underreporting, for example, with respect to domestic violence. Most women that are subject to domestic violence don't ever report that to police. The same can be said for things like break and enter or theft from auto. Many people don't even bother reporting those police anymore. In fact, for the fact that police often won't even bother to show up to your house or to your car because they simply don't have the time to do so. So many victims have given up reporting theft from auto. And in fact, if they do report it and report it to their insurance company, their insurance insurance rates may go up. So some cases are not recorded as crimes by police. In one jurisdiction, you might have a case in a particular school ground where police lay an assault charge. On the other circumstance, police may just view this as bullying and let the school authorities deal with it. So it often depends on the jurisdiction as whether a criminal charge is going to be laid. But again, in many cases, police will not lay a charge and won't record a particular incident as a crime. Obviously, in a majority of crimes, no suspect is ever identified. The suspect may not be charged. The charges can be withdrawn by the victim or the prosecution. The suspect may plea bargain or may plead guilty, and the judge may actually dismiss the case at a preliminary hearing. So there's a number of factors that account for this crime funnel. In other words, there's a number of factors that account for why you have so few individuals that are actually convicted and go to jail relative to the amount of crime in Canadian society. And that's simply a reflection of the realities of the Canadian criminal justice system. If every case that was detected by police, or every criminal instance in this country was detected and went to trial, there simply would not be enough resources to be able to prosecute every criminal case in this country. So the criminal justice system, has to make decisions, and it has to use discretion on which charges go to trial and which offenders eventually go to jail.